Welcome, ma'am.
Hi, Julia.
Ma'am, you are muted.
Julia, you'll have to unmute yourself.
Hi, Veena. Hi, Shilpa, darling. How are you?
I'm good. How are you?
I'm fine.
I'm
I
seeing
guess we're in the call now.
I'm seeing you after years.
I know. I'm so glad we've kept in touch.
Yes. And thank you so much for accepting my invitation at such short interval.
That's okay. I just hope you'll be okay.
Yeah, it will be. Julia, we'll just start in 5 minutes. One session is going on. All the experts are joining. In 5 minutes, we'll start the session.
No problem. Just a question. Does it say my name on my screen? Because I don't know how to work Google Meet.
Yes, that will be presented.
Okay.
The screen sharing will be done from our end.
Okay. But can you see my name?
Yes, I can. Yes, we can.
Okay. All right.
Good evening, everyone. We are starting in 2 minutes. We are waiting for other resource persons to join. We will start in 2 minutes. Good evening, one and all. Welcome to the experts talk session. I, Dr. Veena Roshan-Jose, faculty in charge of this session, welcome Dr. Shilpa Jain, associate professor and convener of this conference, to welcome the gathering. Madam, please.
A very good evening to one and all present here. I welcome all the resource persons and the experts who consented to be a part of this expert talk at a very short notice. My heartfelt gratitude to all the experts and the resource persons once again. And without coming in between the participants and the experts, I would request Dr. Veena to start with the session, please.
Thank you, madam. Now I call upon Mr. Ashit Srivastava, Assistant Professor of DNLU, to introduce the experts and moderate the session. Over to you, sir.
Thank you so much, ma'am. Thank you everyone for joining us at this evening at this late hour, IST, that is Indian Standard Times. It might be early for someone who are across the globe. We welcome you all at the International Conference on Changing Dimension of Human Rights in Globalized World. In today's session, we will be having 4 themes, and we are dividing the themes as per the speakers. So I'll introduce the speakers as per the themes. So theme 1 is human rights of vulnerable and marginalized population. The speaker would be Dr. Karabo Ozaha. She's a director at Center for Child Law, Faculty of Law at University of Pretoria. She's an exceptional lecturer at University of Pretoria. Currently, she's also a member of the expert group on parentage and surrogacy of the Permanent Bureau of the Hague Conference on Private International Law. In the same theme, we have Dr. Mariam Jabin. She is the chairperson of Equal Rights Initiative Maldives. She is the Secretary General, Bar Council of Maldives. Dr. Mariam did her doctorate from University of Waikato in the topic of local implications of international human rights law. Dr. Mariam also did her Masters of Law in International Human Rights from University of Pennsylvania Law School. We welcome you, ma'am, to this panel. Then in theme 2, which is Science, Technology, and Human Rights, we have one speaker, Ms. Julia Selman Ayate. She is a senior lecturer in law at University of Cape Coast, Ghana. She's a doctoral candidate at Institute of Air and Space Law at McGill University. Ms. Julia did her MPhil from University of Cambridge. We welcome you, ma'am, also to this great August gathering. Now, we move to theme 3, and theme 3 is human rights and environment, and for which we have Professor Dr. P. Leelakrishnan. Professor Dr. P. Leelakrishnan is a former professor and dean, Faculty of Law, Cochin University of Science and Technology. Dr. Leelakrishnan has taught law at Cochin University for more than 30 years now. So that's more than 1/10 of what we have taught by now. He has written a lot of books, several articles and publications in environmental law. He has a versatile career as a researcher, professor, and a lawyer. We are more than honored to have you, sir, as a host, to host you as a panel speaker today. In the same theme 3, we also have Professor Dr. Antonita Elia. She's a senior associate fellow in law, interdisciplinary unit on globalization and climate change, University of Santiago, Spain. Dr. Elia is also an external associate legal expert at European Asylum and Support Office. Dr. Elia also was a former candidate to the European Committee for the Prevention of Torture. Thank you so much, ma'am, for joining us today in this panel. And then the last theme is the national and international perspective. We have Mr. Daniel Stewart. Mr. Daniel is an executive director at Independent International Legal Advocates, New York, USA. Mr. Daniel also has been an associate legal officer at United Nations, as well as a legal officer at United Nations. Mr. Daniel has also served as an adjunct professor at Columbia Law School. So we welcome all of you to this August gathering at such short notice. Seeing the panelists, it feels like that we are in a Marvel movie right now with so many Avengers ready to guide us to the cause of human rights. We need to understand that somewhere down the line that human rights is a very fragile and sensitive topic, and the themes, I think, justifies this idea that there are different reinforcing agents across the globe which are having their deep impact on human rights. So without any further ado, we'll start with theme 1. And the stage shall be taken by Dr. Karabo Ozar. Ma'am, am I audible to you?
Yes, thank you very much. Am I audible?
Yes, you're audible, ma'am. Just one
Thank
thing.
you. Yes.
I forgot to say, we welcome you, ma'am, and thank you so much for accepting our invitation to be a panel member today.
Thank you for having me. It's no problem. Thank you so much for this invite to this great conference. I just want to make a clarification that I am Miss Oza, not doctor.
Okay.
I still have to work for my doctorate. No worries. But I also want to say upfront that the center that I work for is based within a university, and I do teach, but we actually do litigation, strategic litigation on children's rights. So I have to say that because my talk today will focus a little bit on how during the hard times that we're in. I mean, we are on this platform because we are facing challenges in relation to seeing each other in physical form because of the pandemic that we face in the country. So I decided that maybe the appropriate talk is for us to have a pause about how has the pandemic impacted on children's rights, particularly in South Africa. I'll give you a few examples where I'm focusing on access to education and nutrition and food, actually people going hungry because of the pandemic. So thank you so much for this opportunity. So as I already mentioned, I mean, last year we were all faced with the challenge that is that we got to know of COVID-19, which is a virus that still has most of our countries under lockdown. In South Africa in March 2020, there was a decision taken that we have to go in lockdown. Initially, this was meant to be for a period of 21 days to see if we can somehow manage the virus and, you know, be ready to give those who need healthcare the appropriate healthcare. All of you know that till today we're still under serious problems, and in South Africa we currently actually have a second wave that has had more of a death toll than the first wave. So what did the pandemic mean? What did that COVID virus mean? So we went into 21 days, which was later extended for a few more days. And then we realized that the numbers were going up. And in South Africa, there became a need then to have a hard lockdown, which is like a strict lockdown, which most of our countries have gone through, where only essential service people are allowed to move. That also meant that children were not allowed to go to school. At a time where initially when the lockdown happened, they had been on recess, and when they were supposed to go back to school, they were not going back to school. And organizations in the country that work on children's rights and human rights started being concerned about the fact that we have in our schools a school nutrition program that feeds about 9 million children, that if they're at home every day and we don't have sufficient other forms of social services and social security, security safety nets, we're actually literally going hungry. And as a result of research done and work done by organizations such as Equal Education and Equal Education Law Center and Section 27, who actually do work directly with learners on the ground, they then launched a court application to try and force our Ministry of Education to make provision for children to still access food, even though they're not going to school. At that time, what they had told us was that there is a plan to what they call phase in, that going back to school and have the older children come back first and then the smaller children later, and that only those who then go to school will be the ones given food. And this is what then had to be challenged in front of our courts, because there was evidence that children were definitely going hungry because their parents, you can imagine, those who are informal traders cannot trade, those who work were losing jobs already. You are really not allowed to move around in any way, shape or form, and people were going hungry. The court papers detailed how some of the older children who were already going back to school could get food at school, but when they come back, they have to face the reality that their siblings have gone hungry, because for some people that one meal per day for some of the children was the meal that actually kept them going, because the scheme is actually aimed at the most impoverished members of our society. So already the 9 million children who are receiving this come from families that have nothing else. And really the circumstances they were under were dire. Also attempts to try and see if there was any other form of education that could continue in terms of online platforms and all that were not really working. And there were challenges in relation to that, the fact that even if you do have that working, how will children who are hungry be able to concentrate and study? So The center that I work for intervened in the case to make the arguments based on international law. We all know about the UN Convention on the Rights of the Child and its general comments. There's some that focus on specific issues such as health, and in health, it also includes nutrition. And we made submissions that the right to health should be the right to education, forgive me, should be read together in these circumstances with the right to nutrition for these children, because they were not merely accessing education, they were actually also having access to nutrition. And what we found is that our own government had, in their reports to the UN, in their reports, in the peer review reports under the UPR, actually said that their program is such a great program, the school nutrition program, and is actually working also to alleviate hunger. So it's part of providing nutrition to children and to our communities. So they've never pitched this as just being, if you happen to come to school, you get a meal by the way, kind of a thing, which unfortunately was what they were presenting now before the court, that, oh, we just happen to provide them food while they're at school, but not really wanting to ensure to be pinned down on the fact that the two were linked and they continue to have an obligation to provide food to these children. The case was successful in court, and one of the most important aspects coming out of it in terms of interpretation of rights is the court reminding our duty bearers that rights of children are interdependent. You cannot try to divorce one from another, particularly where right from the start you already had the obligation and you had undertaken it, where you also now get into a point where the state wanted to regress in relation to the provision to the learners. Now, most of you would know that court judgments are only as good as the implementation that comes after them. And our organizations actually had to now start holding government accountable in relation to the court order. And Section 27 and Equal Education are doing a lot of work where the court actually gave a structural interdict that the government must report all the provinces and the national minister as to how they are re-implementing that program, how many children are they really reaching, because there were disputes about the fact that some of the provinces were alleging that they are actually providing food to children, whereas the parents and the learners on the ground were saying nothing has reached them. So that process of actually supervising the implementation and ensuring that government is actually giving food to children has continued. But nonetheless, on the issue, and I'm going to focus again on the issue of hunger, which it persists now as well. And most of our countries, probably in India, I know there are also debates about going back to school across the world is a big issue. When children at home, hunger faces them. When we did this case, we started questioning, you know, these children that we get meals from school, what happens to them when there's holidays, school holidays? It's not like food magically appears from somewhere during school holidays. And those are some of the takeaways from this case, that this year we're trying to focus on holding our government accountable insofar as also providing for children and seeing children holistically, and not having the siloed approach where one ministry will say, well, I give them food when they're in school. I don't care really what happens when they are at home, which is kind of the kind of responses we get. I'm mindful of time, but I want to just quickly maybe say from a broad perspective and not focusing just on South Africa. The pandemic has meant a regression on quite a lot of people's human rights. And I had been in one of the other sessions, and one of the things that I think we need to reflect on as scholars, as practitioners, is what does it mean? Because you know, one thing in South Africa, for instance, budgets had to be cut, including budgets to school infrastructure, to even some of these feeding schemes, because we need vaccines, because we need other measures to try and respond to the COVID-19 vaccine. And we need to actually be thinking about what does this mean short-term and long-term in terms of budgeting for children's rights, in terms of also the ideals and all the aspirations and promises that were there in relation to the rights of the vulnerable groups before COVID, because those things still exist. And if anything, I think COVID has exacerbated the situation of the marginalized group that we're talking about today. If anything, they find themselves more in a dire situation than they were before. And I think we need to be looking at that. I mean, in our work, that in our submissions to court, one of the things we did is that we worked with academics who do research at other universities, and we could provide proof of the levels of poverty in our country and what the school nutrition meant for those communities. And now we need to do continued research to say, this is what it continues to mean because there are more job losses. And how do we now, with the reduced fiscus, hold our governments accountable in relation to that? In relation to schooling, again, one of the big issues, the fact that children have dropped out of schools. Somebody needs to hold our governments accountable as things become, and when they do become better. What happens to those children who've fallen through the cracks? How do we bring them back to schools? How do we find ways of doing something for them? I do know that we try to talk about human rights as the treaties and all that, but in the work that I do, the treaties must become alive, our constitution must become alive, and that's why some of us do litigation to actually take government up where they have failed. So I would want to urge all the participants of the conference or the presenters in their different spheres. From academics, I mean, there's a need to reflect about COVID's impact from a research perspective, but also there's also a need to go and understand what it means for the realities of the people so that we can at least advocate for better, because if nobody does that, if anything, whatever gains all our countries have made so far in relation to the protection of human rights will mean nothing. Thank you.
Yes, I think we can keep the Q&A at the end of the session. So if anyone has a question to Ms. Karabo, then we can keep the Q&A until the end of the session. We'll move to the next speaker of Team 1, that is Dr. Mariam Jabin. Ma'am, are you here? Dr. Mariam Jabin, Team
Yes.
1.
Yes.
Yes, hello, ma'am. Right, so the stage is yours, ma'am. We wait to be enlightened.
Thank you so much. I thank the organizers of this conference, first of all, and first and foremost, for inviting me to be part of this. And it gives me great pleasure to address this audience and to speak briefly about my experiences working with human rights of vulnerable and marginalized groups in the Republic of Maldives. Vulnerable groups are, as we all know, certain groups or certain population groups that often encounter discriminatory treatment or need special attention to avoid potential exploitation. And these groups, or some characteristics of these groups, include groups of individuals who are socially vulnerable, tend to be victimized, perceived as having somewhat lower place in social structures, or considered by the public as being different from the majority. So these are just some of the characteristics of what constitutes persons in vulnerable groups. The question really is, do we do enough to ensure the rights of these vulnerable groups? My brief speech today will highlight key issues with the situation of rights of women in the Maldives, with a particular emphasis on the issue of inequality. So the Maldives is an exceptional country. It's an island nation of approximately 1,200 islands. Although small, it has a widely dispersed population, which remains a key challenge for national development and sustainable development goals. And despite these challenges, the Maldives has made remarkable human rights achievements in the past 30-odd years. In education, we stand at par with first world countries, and gender parity has been achieved in literacy rates, enrollment, and attainments at primary, secondary, and tertiary levels of education. We achieved gender parity in education only within approximately 70 years, which is quite less in comparison to many countries in the world. The first formal school for girls was introduced in 1933, and girls were unable to travel for higher education until 1946 in the Maldives. Today, however, we have more female graduates than men, and the majority of the high achievers at the secondary and tertiary levels are currently women and girls in the country. There are islands in the Maldives with a total population of only 400 persons, of which school-going age children would be very few. However, every inhabited island in the Maldives has a school. Maldivian women enjoy equal rights and access to health services, and the Maldives maternal mortality rates have also seen considerable progress over the last few years. And these are the main achievements in terms of human rights of women in the country. The Maldives has also made significant strides in efforts to establish both formal and substantive equality, as we have aspired to under the International Convention on the Elimination of All Forms of Discrimination Against Women, which is CEDAW, which we became a part of in 1993. Key legislative developments in the country since we became part of CEDAW includes constitutional equality, which now we have, which prohibition of discrimination based on gender. Other key legislations, including the Domestic Violence Prevention Act, which has legal provisions to ensure that victims of domestic violence are given adequate protection and safeguards. And under this act, Family Protection Authority was established, and there has been an increased national effort in recent years to raise awareness on gender-based violence and domestic violence in the country. Sexual offences legislation, anti-sexual harassment legislation has also been key laws that's been developed to ensure protection for women. Like many countries and the global statistic, 1 in every 3 Maldivian women also suffer or has experienced domestic violence. And therefore, this has been a key area in which the government is trying to make progress in terms of addressing the issue of domestic violence. In 2016, we had the Gender Equality Act, which was a milestone legislation which prohibits discrimination on the basis of gender, harmonizes the existing legal framework with the Convention on the Elimination of All Forms of Discrimination Against Women, and promotes gender equality in the Maldives in a cultural, social, economic, and political context. And the Act outlines explicit duties and responsibilities for the state, the private actors, and prohibits victimization and remedies. Is there an issue?
No, ma'am, please go ahead. Please go ahead.
And introduces remedies for discrimination based on gender. So in societies around the world, female statuses are generally viewed as inferior and subordinate and are argued to be the natural order of the humankind. And the historic subordination, silencing, and imposed inferiority of women are not simply features of society, but a condition of society. Legal precepts traditionally excluded women from centers of male gendered power, including organization and conduct of warfare, hierarchical organization of influential religious institutions, attribution of political powers, authority of the judiciary, and influences that shape the content of the law, such as legislatures. This is not new to, I guess, many of our countries that we come from, and we've experienced this everywhere globally. Similar trend is also seen in the Maldives, and there's a gender dimension to law and justice, which is highly observed but rarely identified as an issue or ever attended to in this country. During her visit in 2013, the UN Special Rapporteur Gabriela Noel paid particular attention to the integration of a gender perspective and women's rights in the justice system. She noted that while there has been progress since 2008 to appoint female judges to the bench, there's no policy or strategy to increase women's representation on the bench, and the approach of the system, law and justice sector institutions included, is still quite conservative and representative of a highly traditional and patriarchal societal structure. Gender biases and discriminatory attitudes and practices are widespread within the judiciary and the administration of justice. Despite nationwide training to sensitize law and justice sector officials on the new laws, both the ignorance of the law and the rejection of the law is common amongst judges, magistrates, prosecutors, lawyers, and the police. There are many reports of police officers refusing to register reports of domestic violence, and the country is yet to see positive progress in the realm of prosecution. There's a strong social belief that women are supposed to stay home and look after their families while men must work and provide economic support to the families. Even with the rising pressure of sustaining families in the capital with one-income salaries, it is believed that a woman's place is the private sphere of life, and this is reflected in the limited participation of women in positions of power and decision-making in the Maldives. It is also noted that women are not properly educated about their own rights and are subjected to strong social pressure and stigma, especially concerning sexual violence, which prevents them from denouncing violations and bringing their cases to the courts. In addition to these, multiple access to justice studies in the country have shown that women do not trust the police nor the courts to provide them with justice. So a few minutes ago, there was, the first presenter actually spoke about how the pandemic has affected rights. And I think the pandemic in the Maldives has also highlighted the already existing problems in the system. One, that there's no way to report, if we are talking about domestic violence, there's no way to report violence and abuse. The challenges of getting protection in the form of protection orders from the state institutions or restraining orders from the courts, and the impossibility of seeking adequate and timely health services when it comes to sexual offenses or domestic violence cases. These circumstances are exacerbated when the situation involves outer islands and women from lower economic classes in the country. When partners abuse or hit women, they would usually run to their families. However, the pandemic could have prevented this form of support, and it is unclear how women have afforded temporary shelters by the state or the police services. It is, however, a fact that major office buildings and service centers in Malé, which is the capital island in the country, and across the country were closed during the lockdown and would have prevented reporting as well as attaining the necessary protection services to these victims. Marginalized women, therefore, not only suffer violence from their betters, but also from the state by the lack of adequate institutional support in the form of social services, shelters and coercive controls by the states and its agencies, and this violence occur in gendered and caste manners. So what can we do really about this situation? We need to give prime importance to two areas when addressing the issue of women's equality. One, empowering women and girls and eliminating. Secondly, eliminating toxic masculinity. For example, an effective response to domestic violence addresses the immediate and long-term needs of women experiencing abuse and focus on changing cultural norms, attitudes, and legal provisions that promote the acceptance of male superiority and undermine women's enjoyment of their full human rights and freedoms. Herein lies the problem in the Maldives national strategy. While it focuses on aspects such as criminalization of the act of domestic violence and providing protection to victims, rehabilitation of perpetrators, and ensuring justice for victims, there's limited to no attention on the second aspect of addressing domestic violence, which is about really finding out what the issue is and trying to address that aspect of masculinity or patriarchal systems that we are living every day. Both the state, UN agencies, and civil society groups in the Maldives work towards empowering women and girls. However, there's sufficient interest in generating information on why men better their partners are absent. These authorities and human rights defenders may also pay equal focus on preserving traditional masculine values that men must mask distress, emotions are feminine and weak, must maintain hardness and violence in an indicator of toughness and power. Thus, equal attention must be afforded to redefine manhood and empowering men to combat these social values that negatively affect both men and women in the Maldives. Another reason affecting women's rights is that the law, the institutions, and society all fail to understand that women, female, and disempowered are also affected by multiple and complex combinations of different forms of discriminations, overlapping, amplifying each other, which has a negative effect on their rights. Many of these features are quite visible in the Maldives. For example, rural and poor women never get elected to the parliament or become judges or cabinet ministers. Women also find it harder to access loans from commercial banks. When multiple oppressions overlap in the experiences of an individual, creating interconnected barriers and complex forms of discrimination that can be insidious, colored, and compounded. For example, the barriers and challenges faced by a poor, uneducated woman from a remote island who is running for a seat in the parliament will be compounded due to the intersecting vulnerabilities of gender identity, socio-economic realities. Being a woman, being poor, and economically dependent does not exist independent of each other, but rather they inform each other and creates complex convergences of oppression for women. Majority of women in the Maldives are financially dependent on their husbands or families and have little to no recourse or support outside of their families. This makes seeking assistance and protection in domestic violence cases particularly hard and almost impossible for the majority of the victims. I know the story that I told at the beginning of my presentation and the story that I'm telling right now is quite different. And this is exactly what I want to highlight, that Maldivian women have achieved universal equality in education, are employed, many women are actually employed, many are independent. However, these inequalities still continue to date. They're dependent on their family members. They do not take informed, empowered choices. There's a lot of domestic violence. There's a high inequality in terms of participation in decision-making positions, being a part of the judiciary. Only very recently, we've had female judges in the country, and this can go on. These are quite telling numbers indeed. So what next for the Maldives? Given the social context, it must be borne in mind that deconstruction of inequality does not only require social movements which openly confront and names damage, but also brings individuals' stories to forefront. It also needs a nuanced approach to reframing women's rights in the Maldives by paying equal attention to the issues of violence of the law, addressing toxic masculinity, and paying adequate attention to the intersections of gender, class, and abilities, and how this affects women's experiences and equality. And I think lastly, but most importantly, comprehensive sensitization and awareness raising programs on gender equality and women's rights continues and will continue to be of critical importance for all state institutions, including the judiciary, prosecutors, and lawyers, in order to push for a change regarding the patriarchal and discriminatory attitudes and practices, and make access to justice a reality for women in the Maldives. That would be all from me for the time being. Thank you so much.
Thank you, Dr. Barrier, for highlighting the issues of the movements in Maldives right now. I actually had one question. I'm breaking my own rule, but I really wanted to ask this question: that do you think there is a commonality of social construct of the South Asian countries and the Maldives, which is quite there? There's somewhere down the line that women are dependent on the incomes of the male, and that is one of the major issues of violation of the rights of the women.
I quite think so. I think we not just South Asian, I think in many countries we have these social structures in which we are taught to believe that this is the natural order of things, and
yes,
this is how it is supposed to be. I believe myself as a very independent, empowered woman, but my mother still today would tell me how to take care of my husband. That's a very example of how things should and should not be in society and how they value things. So
right.
I think, yes, I agree to that.
Right. With that, we come to the end of theme 1. Again, we'll keep the Q&A at the end of the talk. So we'll quickly move to theme 2, that is science, technology, and human rights. We have Miss Julia Selvan Ayate. Ma'am, can you hear me?
Yes, I can hear you. Can you hear me?
Yes, loud and clear, ma'am.
Fantastic. I have some slides. I don't know if someone's going to put them up on the screen.
Yeah.
Fantastic.
Is it visible now? Are the slides visible?
Yes, they are. Yes, they are.
All right, thank you.
And well, how do I change them, or will you do that?
Veena, ma'am? Veena, ma'am?
Yes, sir.
I think you will be changing the slides, right, for ma'am?
Yes. I'll be changing from this side.
Yes.
Okay. Good evening, everyone. I'm Julia Salminaite. As Ashit has said, it's very, very lovely to be with you all. And I also want to give my gratitude to the conference organizers for the invitation. It's very lovely to be here. I'm going to give a very brief, I guess, introduction to the intersection of human rights and outer space activities. And the aim of this brief conversation is not to discuss in any detail, international or domestic human rights laws, but is rather just simply to demonstrate how outer space activities can support the protection and enforcement of human rights, and can also contribute to social and political tension, something that has somewhat been overlooked. Okay, it would probably be easier if I change the slides. Is that possible?
Veena, ma'am, is it possible that ma'am can change the slides?
Sure. Yes, no problem. I'm closing it then. Is it all right?
And what do I press, just to let me know?
And I think Julia wants to say that while you are presenting, can she change the slides? So Julia, no, that would not be possible. Only one who's presenting the slides can change the slides. So whenever you want the next slide to be displayed, you can just say that please turn to the next slide.
Okay,
so
fantastic.
Yeah.
Okay, so the third slide. The question is, why are we talking about space at all? Quite clearly, you are all scholars and students of human rights, and we know that there are still significant human rights issues here on Earth. Why do we need to spend time talking about space? Well, it's precisely because there are these unresolved issues on Earth that the way in which space can provide solutions to helping us both here on Earth and ensuring that as we move, and many do believe we're moving to become an interplanetary species, we can make sure that we do not repeat the mistakes we've made on Earth in outer space. Before we continue on, we need to kind of distinguish between old space and new space. Old space, we can say, was the dawn of the space age. It was a time when space activities were state-based, really, were state-dominated. The two main space powers at the time was the then USSR and the USA. And the main purpose of space activities at that time was scientific exploration. The characteristics of the space industry at that time was mainly, it was risk adverse, it was very expensive, and it relied on traditional scientific knowledge. If we fast forward to 2021, it has moved from space activities being primarily carried out for scientific reasons to a variety of military, civilian, and commercial activities. It is dominated now, I think it's safe to say, dominated by non-state actors. That is a big difference. And space industry now is very dynamic. They're willing to take risks, and it's much, much cheaper. And it relies on a lot of innovation between different industries and different fields of expertise. Carry on, please. It's also important to highlight that this is not some abstract thing that we're talking about. We all use space every day, from GPS to our electronic banking. Space is important. And it's also important for us to realize that it's not simply about providing essential services or national security considerations, or ways in which space can be used to simply improve the niceties of human life, if you want to put it that way, but just getting down to basics. Individuals who are suffering from droughts, or who are being co-opted by corporate entities, or who are fleeing war-torn zones, can be assisted through the use of space. Go ahead, please. I think we need to just really highlight very quickly how space activities, those activities that are conducted in space or through space, are governed. We have international space law, and on the one hand, it is governed by general public international law, as well as customary law and general principles of international law, as well as the Constitution and Convention of the International Telecommunications Union, for example. But really, the meat of the international space law, what we call the lex specialis, are the 5 UN space treaties, the 5 United Nations space treaties. The primary one is the Outer Space Treaty of 1967, and that really provides the backbone, the framework, the skeleton of how the utilization of space is supposed to be undertaken. And then the other 4 treaties kind of build upon the general broad principles that are laid out in the Outer Space Treaty. There are some key provisions that I think we need to highlight that are visible on the next slide. I won't read them all, but it's important to note that unlike a lot of other areas of international law, the Convention for Space states that it is the province of mankind. Therefore, it is not subject to any sovereign territory. It cannot be divided up, or should not be divided up. It is not subject to sovereign division. It is supposed to be used for the benefit and in the interest of all countries. And very importantly, in Article 2 of the treaty, it is not subject to appropriation, meaning no matter how many American companies go to space, for example, space resources do not necessarily become property of the United States. It's subject to non-appropriation. But we must highlight that this treaty and all the others are only applicable to states. They do not directly bind non-state entities that have the capacity to go to space and conduct activities there. what we really need to then highlight, if we go to slide 8, and just conscious of time, is looking at human rights activities. The next slide, please. Human rights activities in two perspectives: human rights in outer space and human rights through support of space-based tools here on Earth. So looking first at human rights in outer space. We all know there have been astronauts. There's also have already been space tourists, for example, the Iranian businesswoman Anush Ansari, and companies like Virgin Galactic and Blue Origin are planning to conduct space flights. In the case of Virgin Galactic, for the cost of approximately $200,000, you can buy a ticket to go to the edge of space. And as Elon Musk would have us become an interplanetary species, he is planning to provide or set up a human settlement on Mars. And if that does come to fruition down the line, we will then have space residents. So with all this, it's clear to see that space will have more human engagement, and where there's more humans in space, there'll be more social interaction. And where there's more social interaction, we do need to consider the issue of human rights and freedoms. The question then is, do the human rights that we've come to know and respect here on Earth, do they apply in outer space? That's the million-dollar question. And I don't think anybody can say for sure that it does. We know from our laws here that human rights apply within a state's territory. Human rights can also apply extraterritorially in other jurisdictions. But the question is, does that mean it can apply extraterrestrially? It would seem prudent that it does. If we're going to have humans conducting business or living in outer space, surely we should have human rights there as well. So I don't think that's the question. The question is rather, how will it work? Who will enforce it? How will it be enforced? Then if we move to the second perspective to look at this, that is how human rights on Earth can be enhanced or protected or supported by outer space activities. And we're going to look at one in particular, which is remote sensing. We move on. Now, remote sensing is the acquisition of information from a distance. There's no physical touching, and when remote sensing is used to obtain information on the Earth, that is referred to as Earth observation. And Earth observation could be provided through a number of means. For our purposes, we'll just concentrate on images and video. It's particularly useful in a scenario where you have, for example, large swaths of land or hard to reach areas or dangerous areas. So if we think of some of the detention camps in Northern Korea or China, or we think about conflict zones, Palestine and Afghanistan, those are areas where research, remote sensing can be particularly helpful. And it helps improve advocacy, it helps improve accountability, and it can lead to both policy and legislative changes. So let's give some specific examples of how remote sensing can be used to support human rights, which is next. It can be used through human trafficking, slavery, succession campaigns, boundary disputes, that has been a particular one, forced displacement, archaeological research, and the international crimes, for example, of aggression and genocide. All of these travesties have implications for human rights. Some of them are listed here: freedom of movement, the right to self-determination, the right to highest standards of mental health, not to be subject to torture. Some of these human rights are enshrined in legally binding treaties. Others are simply influential norms, but nevertheless, remote sensing can be used to deal with these human rights violations. And how exactly can remote sensing do that? If we look at the next slide, it highlights that it can be used for detection and monitoring. So it will detect not only the fact that, for example, human trafficking is happening, or that there is a prison camp where torture is occurring, but it can help us monitor the severity of it. We can help us monitor when it's occurring, how it's occurring, who's carrying out these violations, and whose rights are being violated. So it's able to provide information that some other forms of evidence are not able to provide, or it's able to corroborate for litigation purposes that other evidence, and which leads to the next point, enforcement and evidence. Nope, go back. The remote sensing data, the pictures, the videos, for example, are used to enforce human rights and for evidentiary purposes. So, for example, both the International Criminal Court and the International Court of Justice have accepted satellite imagery as evidence. One clear example is the International Criminal Court prosecution of the Sudan's former defense minister, Abdulrahman Mohamed Hussein. Satellite imagery was accepted by the ICC in his prosecution. So it can aid the prosecution of international crimes, for example. It can also help with regards to treaty compliance. There are some international conventions, primarily environmental, relating to environmental law, that specifically provide for remote sensing to be used in a manner that can help monitor treaty compliance. And this enables states to take corrective action where individuals' environmental rights, which also link with human rights, are affected. They can take corrective action, and it also enables the international community to carry out sanctions based on reliable, legitimate data, which shows the continual disregard of treaty obligations. So therefore, we can see through these few examples that remote sensing, which occurs through satellites in outer space, are able to enhance accountability, reduce harm to our fellow humans, and help the international community to more effectively plan and implement their human rights interventions. So that's the good part about remote sensing and how outer space activities can be used to alleviate or support human rights here on Earth. The question is, what are some of the challenges? And this has somewhat been overlooked. There are a few academics or scholars who have touched on it, but it's something that we don't generally talk about, and I think it's quite important. If we move to the challenges, the next slide, remote sensing can lead to discriminatory geopolitics. Now, why do I say that? Well, the question is, who has access to the satellite imagery? Who owns the satellite? Who's producing the data? Who's selling the data? Who can afford to buy it? If we take that trial of the Sudanese defense minister, the satellite imagery that was used by the International Criminal Court was collected by the Sentinel Project. Now, the Sentinel Project was funded by Hollywood actor George Clooney. So clearly this shows that non-state actors, in this case, an individual, may directly use outer space to impact international law in action. In this case, it was a good thing. It was trying to ensure that somebody who has committed human rights violations was held to account. And many people would appreciate this humanitarian purpose behind George Clooney's actions. However, critics have stated that, on the other hand, it shows that rich Western men acting in a personal capacity, not a governmental or international organization capacity, but acting in a personal capacity, can determine which poor person of color from the South is prosecuted publicly. So this raises questions of justice. It also relates to an issue of whether the West is using its ability and its control of remote sensing to surveil and intimidate non-Western countries. So, for example, we see very often on the news images of Syria, of Myanmar, of Sudan, North Korea, China, but we really don't see examples of remote sensing being used to show what America or the British government are doing, for example. There's an issue of what's called shutter control. countries who have the rights over these tools determine what is seen and who sees it. And we know that America, for example, has purchased all the rights to images in Palestine at a particular time. We need to think about enforceability. If we look back at human rights in outer space, sure, let's say it applies, who's going to enforce it? Unlike the law, the tribunal for the sea, there's no tribunal for outer space. So where do we go to enforce our human rights that may have been violated in outer space? And finally, legal validity. There are issues with standardization. There is a Western bias. So we need to be sure that we're not just taking the images produced at face value, but ensuring that there are certain standards that can be respected. So my overall message to you finally on the last slide is just to demonstrate that the last slide, that outer space activities can be used to support human rights, both in outer space and here on Earth, but it does have some downsides, and we need to minimize the disadvantages and maximize the advantages.
Right. I think we have one question, but I'll suggest that we can limit the questions to the end of the session. If ma'am wants to take the question, that's not an issue. Ma'am, can you see the question?
Can I see the question?
Yeah, it's in the chat box. Should I read it out?
Yes, I see it. How do you look at the aspect of right to privacy vis-a-vis remote sensing? That's a great question. And we can talk at length about it, but just very briefly, both the right to privacy and the right to data protection are significant issues for remote sensing. There are countries, there are the sense countries and the sensing countries, and it's becoming an increasing issue because now the pixelation of the images are so great that you can see, a car's license plate. You can even see through the window into somebody's house. So countries who are permitting their territory to be surveilled through remote sensing need to ensure that they have legislation in place to govern the respect to right for privacy.
Right. We'll quickly move to the theme 3 of the law talk today. Theme 3 is human rights and environment, for which I shall be calling the first speaker. That is Professor Dr. P. Leelakrishnan. Sir, am I audible to you, sir?
Yes.
Yes.
Am I audible to you?
Yes, sir. Loud and clear, sir. And it's an honor, sir, to have you for delivering lecture on environmental law.
Thank you very much, Professor Ashish Srivastava, as well as Professor Veena Roshan, and others who have organized this wonderful seminar. When you think about human rights and environment protection, you should have a glimpse into the growth of human rights, right from the days of Magna Carta in 1215 to the decisions and the legislations in England, as well as the growing democracy in America, United States of America, settled in Universal Declaration of Human Rights in 1948. Subsequently, expanded further with so many other covenants. Article 3 of the Universal Declaration of Human Rights emphasizes that everyone has the right to life, liberty, and security of person, an idea entrenched in Article 21 of the Constitution of India. Several other freedoms and freedoms of UDHR are now constitutional ideals in the form of fundamental rights and directive principles. Rights such as safe and healthy working conditions, children to be free from harmful work, and improvement of all aspects of hygiene are the directives in the Constitution to guide lawmaking processes. The grave concern or the degrading environment is articulated in 1972 in the UN Conference on Environment, the UN Conference on Environment, Stockholm Conference itself is stated to be a conference on human environment. Later, the Butland Commission, United Nations Commission for Environment and Development, to study how to, was organized to study how to reconcile the development with environment. The report states that all human beings have got fundamental rights to environment adequate for their health and well-being. The Commission advocated sustainable development. What do you mean by sustainable development? Sustainable development is a development that seeks to meet the aspirations of the people or the present generation without compromising the ability to meet those of the future. Their own words. But report state like that. The Environment Protection Act 1986, we call it as EPIPA, framed under the call of Stockholm Conference, is the basic law legislation in India on environment. It now works with a plethora of delegated legislation, rules, orders, and delegation of powers from union government down to the grassroots level of local self-government. In the Act, there is the definition, the environment is defined. Let us look at the definition. Probably that will give us more inspiration for more discussion. Environment includes, when Parliament passed the legislation, the parliamentarians were not so sure of what the environment is. So they said includes, not consists of or means, includes water, air, and land, and interrelationship. And interrelationship which exists among is important. And between also is important. Water, air, and land. And human beings, other living creatures, plants, microorganisms, and property. Among signifies plurality. Among we will not say among between two, between one and another. When there are plurality of persons or things, we say among. So the environment includes water among water, air, land, and human beings, etc. That means all these, the sum total of all these elements will have to be there in as part of the environment. And also then it explains between water and air, the relationship between water and air, relationship between air and earth, relationship between water and human beings. All these are included in the definition of environment. Probably they should have used it means instead of the word includes. Man, a cognitive being, plays a key role in the integration of the environment. But his life is in danger if the environment is not protected and the interrelationship noted in the definition is not maintained. However, this does not mean that man has to consider other living beings and elements solely for his benefits. Such anthropogenic approach to environment may lead to degradation of environment. It is the Indian story of judicial interpretations and jurisprudence that gives the right to environment with a human rights face and form. Probably some of you might be remembering the Ratlam municipalities case of 1980. It is a landmark case. The executive magistrate, exercising jurisdiction to prevent public nuisance under Criminal Procedure Code, had directed the municipality to construct drainage and public latrines within 6 months in order to save the residents from pungent smell from open drains and public excretion. The Supreme Court remarked that providing drainage systems sufficient to meet the needs of the people cannot be evaded as decency and dignity are non-negotiable facets of human rights. One shall not dispute the verdict viewed from the human rights angle. In lines with the MB High Court in Krishna Gopal in 1986 ordered to shut down a medicine factory when its booming boilers were found to have disturbed the sleep of those living nearby. Thus, in order to remove the encroachment of human health and decency, the Indian judiciary has very early developed the law of nuisance as a potent weapon. Notably, in 1976, the 42nd Amendment to the Constitution had already inducted two provisions into the Constitution. The directive principle in Article 48A, asking the state to protect and improvement, and a fundamental duty in Article 51AG to protect and improve the environment. In the same time, one had to note there was a judicial revolution, conceptual revolution in the judiciary in interpreting the fundamental rights. In Maneka Gandhi's case, overruling the old precedent, the Apex Court found that Article 21 generates procedural justice. Not only procedural justice, it starts tailoring, the court started tailoring more and more substantive rights into the right to life concept. Despite these innovative developments, it took a long time, a very long time, for the Apex Court to consider and declare the existence of a fundamental right to a healthy and hygienic environment. The path was clear, but the pace was slow. While rural litigation Kendra case, where the ecology of the region, famous for its resorts and holidaying, was disturbed by mining, the Apex Court seized off the impact, but followed the principle of sustainable development and allowed mining operations to be phased out in due course. In the group of MC Mehta cases in 1980s, where those cases were all on Article 32 petitions, where one can approach the Supreme Court only on infringement of fundamental rights. It is true that the significant doctrine of absolute liability for inherently dangerous and hazardous industry was formulated in one of these cases, but still the cases rolled out without declaration that Article 21 includes environmental rights. However, one notes the history-making Andhra decision in Damodar Rao, where the High Court went ahead in 1986 and stopped conversion of an open space in front of a residential colony into another residential complex, holding that open space is absolutely essential for the people already living nearby, and their enjoyment of life and its fulfillment guaranteed rights under Article 21 of the Constitution. The Rajasthan High Court followed suit, asking the Jaipur city fathers to clean their territory, as the citizens do have the right to health, sanitation, and environment that fall under Article 21. In early 90s, we find that the Supreme Court held that every citizen has a fundamental right to quality of life and living, and to pollution-free water and air, for full enjoyment of life. But the courts could not apply those principles, as the allegations in the cases were found to be false. But however, within no time, in 1991, the title, I would say, the Bangalore Medical Trust versus B.S. Udappa, the Apex Court got the real opportunity to transform the observation of the Supreme Court in the other cases into a dictum and stalled a scheme for establishing a private hospital in an open space. You may be wondering, on the establishment of a private hospital be conducive to general health and is really augmentation of the right to health under Article 21? Of course, it does, but it is curative, but the other one is preventive. The court thought that preventive measures will be more conducive, consanguine to Article 21 of the Constitution. The court laid emphasis on the constitutional mandate for the protection of individual freedom and dignity and attainments of a quality of life which a healthy and clean environment guarantees. Open space being the lung space for urban sprawl is an essential ingredient of a development scheme. Will not, later one finds in SUC case, in Consumer Education and Research Center, 1995, the extension of the right to life to the right to social security, human conditions of work, and to health and medical care, even continued medical care to be continued even after retirement. Why? Because those people who are working in asbestos industry, they may get asbestosis, a disease which may be, symptoms of which may be known only after a few years, after retirement. And so this should extend even to people, laborers who are retiring from service. H-acid is forbidden in other countries, but we are happy to allow its production in our territory. No sooner did the permitted industries go just for a trial run in Bichri village in Rajasthan, then the whole village with its people, children, cattle, trees, and streams was under the siege of pollution. The industries literally ran away, leaving the sludge as such in their village. The Indian Council for Environmental Legal Action versus Union of India, 96, the court holding that the rights of the whole villages are jeopardized, issued several orders for amelioration, that the government should pay court fees, treating the injured as indigent under the Civil Procedure Code. If any organization approaches the Civil Court for compensation, is one of the practical proposals made by the court, but I am yet to hear such an offer was made even afterwards. Development for a few may become displacement for many. The displaced and the helpless people tend to become refugees in their own country. We may call them as living martyrs of development. In the Namada Bachao and Andoran case, the court holds that a suitable rehabilitation with better facilities is their fundamental right, although more often than not, rehabilitative proceedings go with a slow pace with several delays. Undoubtedly, the slogan, develop only after rehabilitation, is a valid demand. The dilemma of the project affected people can be solved only if the powers that we implement this slogan scientifically. As seen in 1999, AP Pollution Control Board versus AP Naidu. There was a ban for locating dangerous industries within 10 kilometers from the lakes supplying drinking water to the twin cities of Hyderabad and Secunderabad. It was shocking to note that one fine morning the government got rid of the ban, while the appellate authority and the High Court approved the action, admitting that even their own incompetence to analyze the technical problems involved. The apex court referred the matter to experts and underscored that environmental concerns are of equal importance as human rights concerns. In the context of emerging human rights and environmental jurisprudence alike, and the inability and incompetence of the courts to decipher technicalities, the apex court in the Naidu's case championed for environmental tribunals. This demand was now fulfilled by the establishment and working of green tribunals from 2020, parallel to the human rights commissions. While the green tribunal has enough coercive powers, human rights commission play the role of an ombudsman and highlight human rights violations in the authorities and public to follow. Concluding, one has to read the message. The combined effect of the eco provisions of the Constitution the directive principles in 48A, and the fundamental duty in 51AG to protect and improve the environment. It is not only to protect the environment, but also to improve the environment. There comes the concept of sustainable development. Along with the right to live concept in Article 21, signify that environmental rights are accepted as human rights under the Constitution. The courts even impose duty on human beings to behave in a humane manner with other living creatures, like bulls grazing in the plains, wild buffaloes wandering in forests, and birds flying up freely into the blue sky. Thank you very much. Thank you very much.
Thank you so much, sir, for enlightening us. We'll take the question at the end of the session, but I really wanted to know your perspective on Uttarakhand High Court judgment regarding wildlife forest as a juristic entity. So you may answer it at the end of the session. If you want to answer it, you can answer it right now. Uttarakhand's High Court judgment regarding wildlife jungles as a juristic entity. They are legal persons.
Wildlife as a legal person.
Yes, sir. 2017 judgment, sir.
That means the wildlife will come under the nomenclature person in Article 21. Is it?
Yes, sir. Yes, sir.
That is how even in what is called that Madras. What is that race called? Madras bull race. The bulls are given legal personality.
Okay.
And the court said that the bulls have to be protected. They have got the right to Article 21 rights and to be protected by the human beings. When was that the reported that Uttarakhand?
Sir, 2017, sir. 2017.
Which?
2017. Yes, sir.
17. Probably I might have forgotten the facts of the case.
Not an issue, sir.
Anyway, the legal personality is to be, that is the most recent position of the Supreme Court. Of course, there is a conflict of ideas, conflict of interest between federation and the states in the case of abolition of bullfights.
Yes, sir.
In Tamil Nadu, but still, it is being reviewed by the Supreme Court. The final position is still that legal personalities be given to not only to the human being but also to other living creatures, as well as plants. Birds have got the freedom to fly up in the air without being disturbed. They should not be kept in the cages, cutting out their wings. This is the position taken by the Supreme Court.
Right, sir.
Am I clear?
Yes, sir. Thank you so much, sir, for the enlightening talk. We'll move to the next speaker now. Professor Dr. Antonita Elia. Ma'am, am I audible to you? Professor Dr. Antonita Elia.
Yes. Yes. Can you hear me?
Yes, ma'am. Loud and clear, ma'am. Loud and clear. Right. Okay. So the stage is yours, ma'am.
Thank you very much. So before to start my short introduction today, I would like to express my gratitude to Dr. Shilpa Jain for her kind invitation. It is a great privilege to me to be here with all of you today and to share views about many aspects of human rights. And in fact, my sincere congratulations also to Dr. Shilpa Jain for the same name of the conference, which is very impacting in the present time, where we are confronting with many challenges in relation to human rights. So requesting many answers from different perspectives at the same time. As my colleagues previously speaking demonstrated in their presentations, And before to just present a few observations in relation to environment and human rights, and the question of access to international jurisdiction for related human rights abuse, as a consequence of climate change and environmental harms, especially, I would please let me just do some reference to something that I heard very interesting from my colleagues having spoken previously. Because it is important to note that when we talk about discrimination, when we talk about gender empowerment, when we talk about the impact of outer space of human rights, we are not talking on static and separated issues or categories. The first change possibly I would like to suggest is to have a global approach, because what demonstrated the present time of pandemics, as the previous distinguished speaker said, is that there are requests for justice after now and soon after COVID-19, because of the impact of the pandemic on people as individual person and also collectively. So why I'm saying that? Because one common denominator I have found hearing my colleagues is the fact that, but of course it's my opinion, my humble opinion, is that there is a quest of coordination in some ways. There are many doubts, challenges about who is entitled to do, or, for example, just you do, coming back to environmental issues, for one moment, you ask the question about legal personalities of forest and jungle. So I think that there is a question to centralize the issues of human rights, even though with a specific consideration for specific countries or region, but we need to have a central reference. And such a central reference is international human rights law. As we know, international human rights law, which both recognize, define, and also limits the exercise of human rights, of something, or few human rights in accordance. In relation to environment, is undoubtedly that the impact of environmental harms, and here I would just to do reference to the relationship between discrimination and environmental harms. For example, it is undoubtedly that the impact on specific groups, and I don't used to say that women are vulnerable groups, because we must be having in mind that women have been seen as vulnerable group. They are not vulnerable groups. So is impacting more such group than, for example, other categories for example, in the present time. But and in specific regions or countries, as my colleagues, Dr. Mariam Jabin specifically referred to Maldives case. But it's not a problem of only of Maldives. It is a question, or it's a global issue. It's a global problem. with many common points in even in different places. That's why we need to have a global view of the problems, human rights related violations or lack of effectiveness, to find a global reference and give a more possible global answer. That's the first lesson we should learn, in my opinion, from that present time of pandemic. And the same is relating to environmental law. To environmental law and international human rights law. It is undoubtedly that the link between environment and human rights is increasingly stronger and evident. But the approach until very recently by the international jurisdiction today has been something like distinguishing environment from related human rights impact. Who made the first innovative pronunciation or adopt the first innovative address in the framework of international human rights jurisdiction has been the Inter-American Court of Human Rights. In its advisory opinion, number 23/18. That advisory opinion is really important because in giving its interpretation to Article 11 of additional protocol and Article 26 of the Inter-American Convention of Human Rights, very briefly, the court found few important things. And here I will relating to the need to have a global approach to human rights challenges, especially for jurists, but not only. Firstly, for the first time, and we are talking, the order is of February 2018, so it's very recently. Defined for the first time, recognize the right to an healthy environment as specific right. Doing that interpretation of aforementioned articles, defining the right to a healthy environment as essential to the effectiveness of other rights, and especially economic, social, and cultural ones, right to health, right to water and sanitation, and so on. But the order is also very interesting because recognize the underlying other important things. The question of transboundary environmental arms. That means, that one of the issues related to international jurisdiction, international human rights jurisdiction in general terms, is the question of jurisdiction, the limits to jurisdiction, and the concept of territorial limits of jurisdiction. In that order, the Inter-American Human Rights Court, in an innovative and teleological way, interpreted the Inter-American Convention transforming the territorial limit in a control, referring to the control of state not just over the territorial limit, but over its own action. In other way, the territorial, the transboundary, the duty for a state to prevent transboundary environmental harm is based onto the consideration that the transboundary, the control of the state must be not just limited in a territorial way to the territorial border, for example, but must be related to over the control over its own actions. And that's important because of the question of responsibility and accountability in case of human rights related violations as a consequence of environmental harm and climate change, human-driven climate change, because we must bear in mind that climate change can be driven from many factors or by many factors. Sorry. So why I'm saying that? Because if we consider that the responsibility overcome the territorial limits, that means that a victim of a violation of a human right, I mean, question for justice in a state, can ask to an international jurisdiction for responsibility of the agent state, even be in another state, and even in the absence of the nationality link. That's a very innovative address of the Inter-American Court of Human Rights. That's the other point. The second point we must bear in mind is the question of due diligence, the principle of due diligence. What is the principle of due diligence? So why I'm mentioning it? And because of I have heard in the previous intervention few reference to the question of corporations, responsibility of corporations. But in the case specifically of environmental harms and the consequences of environmental harms on human rights, we should consider, in accordance with also the address of the Inter-American Court of Human Rights, but not only, as we are going to see briefly, very briefly, we are just looking for a shared responsibility, which in some cases be concentrated to the existence of the responsibility of state and corporation, materially putting in place the environmental harm. In the case of state, the principle of due diligence means or include the duty to prevent environmental harms causing human rights abuses. What it means? It means that, in the words of the Inter-American Court of Human Rights, but at universal level of the Human Rights Committee of United Nations, that means that a state has the obligation to prevent not only and not just the human rights violation, but also the environmental degradation provoking such a human rights violation. So it's first obligation to prevent. Obligation to investigate diligently in case a violation has been committed, and the environmental degradation occurred, provoking such violations. For example, have a look, just to be clearly on the present time. Approximately 1 year ago, everyone assisted to the deforestation provoked by so terrible fire in Australia. So, and in such cases, of course, there is investigation related, but from a general point of view and using the reasoning of the international jurisdiction, the obligation to investigate is an obligation of the state. In such a case, just to have a picture, a visual picture, but unfortunately we have surrounded of many possible examples in the negative sense. So I started from making reference to the regional Inter-American system because from some point of view has going to develop to strengthen such a link between human rights and the environment based on the exigency of the regional area. But it is also true that the universal approach has also been have been submitted to integrations and new focus. Grateful to the approach used and the reason used by the Human Rights Committee of the United Nations interpreting the International Covenant on Civil and Political Rights. As you know, there are no mention to the respect of the environment as an autonomous human right enshrined into the Convention on Civil and Political Rights, neither in its protocols, additional protocols. However, in the previous year, in the past, the Human Rights Committee needed time to arrive. Thank you to showing me the time. Arrived to needed more time to arrive to resolve to the strengthening of the link between human rights, civil and political rights, and environmental arms in individual cases. Because the Human Rights Committee, according to Article 40 of the ICCPR, is entitled to receive better said, the states party are obliged to send periodical report to the committee scheduling what kind of measures they took for the effectiveness of rights in administrative law, jurisdiction, any kind of sector of the state. So in few different conclusions related to national report, the committee advanced in previous year references to environment and human rights. But for the first case, in an individual communication, it happened in 2019. In July 2019, into the decision adopted to resolve the case Portillo against Paraguay, where Paraguay, very briefly, because we are going to conclude, but I will be very happy to answer soon after to questions and comments. In that case, the committee, for the first time in an individual communication, found accountable the state recognize the duty of state to prevent the degradation of environment, because that degradation provoked the death, in that case, of the victim. So it is the very leading case at the Human Rights Committee, so at the universal level. That means I just mentioned one regional system, the Inter-American one, and the universal level. But this is one really good example that how jurisdiction or quasi-jurisdiction between them at the international level mutually influence them and contribute to the advancement of international human rights law, to have a shared standard globally, to give, as we said initially, a common reference, a common normative reference, and the possibility to find shared and common solution to share the problems. Thank you very much for your attention.
Yes, ma'am, I think you have a question. If you want to answer it right now, you can answer it right now, or we can wait for the end of the session to talk.
No, we can. I can do it with pleasure. My pleasure.
Yeah. So the question is in the chat box. It's the question from Dr. Ranga Swami. Is it visible to you, ma'am?
Yes, I'm seeing. I see.
The last.
That's the question. What's the status of this due diligence principle for China in terms of COVID-19? Okay, this is a very big question, I guess, because we are talking about a pandemic, and it is first we should, from a human rights law perspective, we should define the concept of environmental harm. I mean, may we consider the diffusion of a virus in the environment an environmental degradation? That's the big question we must resolve first. Second, this can be attributable to the conduct of a state. I think on that point of view, I think not. There is not responsibility to a single state to have put in place or diffuse the virus. Unfortunately, it is something that we cannot control, and then science is trying to control right now with the diffusion of vaccine and the preparation of vaccine. On the perspective of due diligence, the possibility to prevent, it is not related just to a single state, to China, I think. That's the question we can do towards every state, every single state. Think, for example, to Italy, just to say one, or Spain. They did any possible thing. They act in the best possible way to prevent the diffusion of virus inside the territory. Of course, that question depends from any single legal order. Just to give you an example, there is a criminal investigation in Italy right now, is going on, to verify the existence of any responsibility in relation to the crime of non-voluntary epidemic. But it depends, of course, from the legal organization, the legal order of a single state. So we should not make confusion between different level of reasoning, I think. And I have another 1 minute. Sorry.
Actually, ma'am, we are really have paucity of time right now, so we need to.
Yeah, I know. I'm really sorry.
We can take the question at the end of the talk, if that's
okay.
yeah.
Yes, of course. Okay, just one point, the last point, the fact that in the case of state responsibility, we should identify different plan, international responsibility, global health law, and human rights law. But I will be very happy to continue soon after in the time of questions. Thank you very much.
Thank you so much, ma'am. Thank you so much for enlightening us with the idea of the extraterritorial jurisdiction somewhere down the line, which is the basis of it, hopefully. Right, we'll move to the last theme of the talk, this theme 4, national and international perspective. And we have Mr. Daniel Stewart with us for delivering the speech on that. Sir, am I audible to you? Mr. Daniel Stewart?
You are indeed, you are indeed. Good morning. Good morning.
Evening, sir.
Oh, good evening, good afternoon, sorry, yes, there we go. Already started with a faux pas. Hello to everybody. Yes, I've already indicated. Welcome from New York. It's a pleasure to be here. Thank you to all the organizers, especially to Dr. Shilpa James. We've known each other for quite some time. Thank all of you for putting me last as well, given the morning. No better way to start a Saturday morning than talking about human rights. And also, thank you for giving a topic or a title that really could mean anything. National, international perspectives. And I'm going to abuse that or utilize that privilege to talk quite widely. I want to thank also my speakers before me. It's been fascinating for me to listen and to get in some of the details of all these particular areas. Based on a sort of a decade plus of work in some of these areas, both at the United Nations and then as the executive director of an organization working with the governments of small developing states, to talk really about these narratives of human rights. The origin of human rights is a series of conflicting and competing ideas from different philosophical and theoretical backgrounds, but the origin of the myths of international human rights law and at the national level is a series both of just history, this happened and that happened, and these narratives, stories, myths about what it is, what it should do, what it has and has not done, and what it can and cannot do. And in the last decade, perhaps I'm cabining it artificially, although it does feel like we're in a new world, at least since Wednesday. A lot of these myths have been challenged, or at least narratives have been challenged. And I wanted to go through some of those in respect to say, how do those stand up to the test of time as we sit here in 2021, in the sense of have they proven to be true and accurate? Where are we in those assessments? So there are many more. This is not comprehensive, but at least 12, 11 narrative myths, and where do they stand over the last sort of decade or so? So one of our first myth was that for a long time, of course, economic, social, cultural rights were sort of the ugly stepchild of the human rights movement. But then there's been a radical, at least I would say, within multinational organizations and certainly academia, to say that in order to save human rights from obsolescence and being seen as Western impositions, that really economic, social, cultural rights would be the center point. How has that stood up? Well, there hasn't been really a dramatic increase in the utilization of the language of human rights and the tools of the international human rights movement in economic and social rights, I would suggest, other than beyond the already leading states, India obviously being one at the national level, South Africa and others. Now, I would say that doesn't in any way alter this argument. It's still very much, we're in that period of contestation. We're having a global economic crisis tied to a global pandemic crisis. Generally, the language of human rights is yet to see prominence, and certainly the mechanisms of accountability, whether the treaty mechanisms or the charter mechanisms at the UN level, haven't been the primary sources of debate and discussion. I think that just suggests that this narrative will continue because it's so contested. So I would say that one is open to debate, or open to, as yet unresolved, whether that narrative will fundamentally change. But of course, many, many more human rights organizations, at least, have begun to appreciate that the exclusive focus on civil political rights, and even the suggestion that economic, social, cultural rights aren't human rights, or at least cannot be part of their firmament because of issues of measurement, has slowly ebbed away, at least from some of the leading international non-governmental organizations. But so very much open to that one, as yet to be determined. A second myth, I think a decade, or narrative, I should say, not really myths, from a decade ago would be that this would be a period of group rights to be cemented and acted upon. How's that stood up over the last sort of decade or so? I'm not saying this hasn't always been true or debates, but certainly rising. Now, on the one hand, we've certainly seen a ever-increasing focus in official discussions, the sort of move to a full treaty on the right to development within the Human Rights Council of the United Nations. We've had the advisory opinion from the International Court of Justice as per the Chagos case, Chagos Islands, very much focused, if not fully exploring all of the contours of what the right to self-determination could mean. Given some of the conservatism of the ICJ, you probably got as much as you could have expected out of them. On the other hand, the true modalities of those questions, in the sense of the right to development as a treaty-based obligation, as that seems to go on interminably. Those who go to those meetings will certainly know that. Like I said, even in the ICJ case, very much focused on self-determination, stayed somewhat above the fray upon the most pressing and most challenging questions about what self-determination as a group right may mean. So, and secondly, those regional organizations, regional bodies, the African system in which group rights are much more central, have continued to be a part, but perhaps no more or less than it was historically. So again, I would give that one a to be decided measurement after the last decade. It's of another narrative that came pushback over the last decade, which was that the introduction of human rights language and arguments into other judicial fora of international law, for example, investment disputes or trade disputes, would dilute or even ruin those areas. We didn't want to have investment arbitrators or trade specialists making or even hearing arguments about human rights. And I would say the last 10 years that myth, or at least that argument, has been exploded. The world has not ended, and none of those bodies have ended in the face of increasing introduction, if admittedly very, very minimal, of human rights arguments, and that's no fault on behalf of those advocating for human rights. And sitting here in 2021, the arguments and pressing for a greater use of human rights arguments in other specialized areas, just wonderfully so, and we'll get to that in a second, in areas like the environment, but even in traditionally, quote unquote, specialized regimes of international economic law, and increasing ever opening for many more states to hear human rights arguments, labor rights arguments in traditional economic forums. So that one, I give a failing grade that yes, I think we'll see ever increasing introduction and use of human rights arguments in areas where there was nervousness from perhaps not those fully supportive of, to hear those arguments. So the next narrative, that there are too many human rights, that if we open them up, if we claim that too many things under human rights law are human rights, will dilute it, will lose the respect of human rights, and governments and states will find even greater reasons not to respect and ensure. Now, beyond the real debate of what counts as the core, and this is to ignore the recent and hopefully wrapped up commission under the previous administration of the United States, to say what the actual core of human rights are, that I think is equally a myth that has also been exploded. Now, the dramatic rise in the use of human rights language in areas, as we just heard, in environment and climate change, marriage equality, has a strengthened human rights law. It forces back into our thinking that really the line of what is a human right is one thing, what should be protected under law is really a centrality of how and where we protect human dignity through law. Now, that doesn't say that there has not been the possibility of the overuse or abuse of this language, but that certainly any concerns about, increasing the number of human rights and who should be protected, I think also has been a failing narrative. Let's move on. 3 to go. Human rights are only about, or human rights law, obligations on states and no other actor. That not only would this be violating the tenets of international law, but it would be quite dangerous that, Now, this is very much an ongoing debate, as we sort of heard, and there are fair arguments sort of both sides, but why I would say this is failing is at least it has reminded us that it's just been a historical choice that classical public international law was all about obligations upon states, and therefore when human rights entered into the treaty making arena in the 1960s and before and after, it was about obligations placed on states. Focusing instead on effectiveness, if we look, for example, in the debates and negotiations now on a potential treaty in terms of business and human rights, transnational corporations, understanding that converting human rights into law is all about responsibility and authority. Now, the national level, of course, governments will obviously debate who should hold that responsibility, who should have the authority. When we subsume and have historically subsumed these questions of human rights into that classical public international law firmament, by placing it all about states, it becomes much more about power and which state should be held responsible, whether we can have responsibility, and less about the effective implementation, who has the authority, who has the responsibility. So I think that one, we're in that sort of narrative or myth-busting moment, as yet to be determined whether that will go in which way. Okay, our penultimate narrative or myth is that naming and shaming, the traditional model of often holding governments to account once those standards are set, will not work in the face of truly determined bad governments, or more importantly, actors who do not face shame or do not feel shame. And I think the last years have said yes and no. On the one hand, the last years have reinforced the weakness of the enforcement systems that we already knew at the regional, multilateral, and often at the national level. On the other hand, it has highlighted the power of the framing of human rights language as human dignity beyond borders. Now, it's also reminded us that really, before we get to law, we have to focus on hearts and minds. People have talked in the language of human rights just as much in the last couple of years as they have before and will do in the future. So this idea that the models are weak or otherwise is true because all law, that's not central to both human rights law, not central to international law, it's just central to the reality of law as a human construction. Final myth, as I'm going through, is that, and I think perhaps I've recognized and worked on this in the last couple of years most of all, is that state non-compliance with human rights law, certainly at the international level, is state malfeasance. It's always been not fully true in the area of economic, social, cultural rights. I mean, built into those instruments and built into our understanding is that the limitations of the resources and otherwise at certain times upon certain states is going to mean got it. Excuse me. But this empirical question about whether or not states non-compliance is about state malfeasance means helping governments is just as important as holding them to account. Now, which governments to help, when to bring claims against them, when they need support, given the massive overload of obligations in the human rights arena placed on governments, that is a debate. But that narrative still, I think, has changed over the last year of an appreciation that sometimes governments are intentionally trying to violate human rights. Otherwise, in the firmament, it's about supporting and aiding them in their attempt as part of that community, as representatives of that community and or people, to uphold the human dignity of their people. So that's the myths and the narratives. I'm sure many, if not all of you, have already discarded some of these narratives and myths in your work and are thinking before. Others think some of them shouldn't be part of our firmament of narratives already. But from this 50,000 feet perspectives of national or international perspectives, I think it just lays bare that the next decade or so is also going to be about setting that narrative. What are human rights for? What can they achieve? How do they really connect at the legal level to protecting human dignity? And I will stop there, hopefully very much within time to avoid being told off. Okay, Ashit, over to you.
Actually, you saved a couple of minutes, actually, sir, of your limited time, which were given.
Perfect.
Right. So due to paucity of time, we might not be able to have right now Q&A because all the three panelists, Mrs. Daniel, sir, Antonita, and Julia ma'am has to be in the panel sessions right now. So I'll ask my colleague, Dr. Veena ma'am, to give the vote of thanks to the panelists.
Yes, I had prepared a long vote of thanks, but due to positive time, I'm just limiting. Thank you everyone for joining us and sharing your thoughts on various facets of human rights today. So thank you all once again, and thank you Ashit sir for moderating the session.
Thank you everyone.
Thank you, everyone. Thank you very
Sessions, it will be starting right now. Those panelists, please join the technical session link.
Okay. Thank you very much.
Thank you everyone.
Thank you.